Welcome everyone to the Louisiana Workers Toolkit for Understanding Your Rights at Work. My name is Cameron Dawson and I'm a staff attorney at A Better Balance. Today, I'm joined by some of our esteemed panelists to talk about ways to support your health and wellness in the workplace. And we will be covering some federal and Louisiana laws that protect employees who are caring for themselves or their loved ones. Next slide. This webinar is brought to you by the Louisiana Workforce Collective, which is made up of the Wage and Hour Division, the United States Equal Employment Opportunity Commission, the Louisiana Commission on Human Rights, as well as the Workplace Justice Project and A Better Balance. Next slide. And I'm joined today by Marvis L. Hicks, who is the Outreach and Education Coordinator for the New Orleans Field Office of the EEOC, Dr. Leah Raby, who is the Executive Director of the Louisiana Commission on Human Rights. And I'm going to turn it over now to Marvis, who is going to say a little bit more about her work at the EEOC and your rights under federal law. Next slide.
Yes, good morning. I am Marvis Hicks. I am the Outreach and Education Coordinator for the New Orleans Field Office. Currently, as the OEC, I am available for providing training throughout the state of Louisiana to companies, advocacy groups, faith-based groups, and any organization who requests training regarding the laws enforced by the EEOC. The Equal Employment Opportunity Commission has jurisdiction or coverage over allegations of employment discrimination throughout the United States based on the following: race, color, religion, sex, and national origin, age discrimination, unequal pay and wages in sex-related matters, disability discrimination, pregnancy, sex, same-sex, and national origin. The Americans with Disabilities Act is our concentration today. The Americans with Disabilities Act covers employees with 15 or more employees and makes it unlawful to discriminate in employment against a qualified individual with a disability. Under the Americans with Disabilities Act, there is a specific definition as to who is a qualified individual with a disability. That's a person who is substantially limited in major life activities like walking, sleeping, maybe combing your hair, brushing your teeth, those type of things. This law also prohibits an employer from retaliating against an applicant or employee for asserting their rights under the Americans with Disabilities Act. The act also makes it unlawful to discriminate against an applicant or employee, whether disabled or not, because of an individual's association with an individual with a disability. What employment practices are covered? The ADA makes it unlawful to discriminate in all employment practices, such as recruitment, pay, hiring, firing, promotion, job assignments, training, leave, layoff, and benefits, all other employment-related activities. Usually, if there is an employment problem, if we are able to establish an applicable statute, we're able to find the issue that's covered under that statute and that employment problem. Who is protected? If a covered employee had a qualified disability that substantially limited a major life activity, including major bodily functions, they may have the right to receive reasonable accommodation, so long as The accommodation does not impose an undue hardship that is not very difficult or very expensive for the employer to provide. Under the Americans with Disabilities Act, a person has a disability if he or she has a physical or mental impairment that substantially limits a major life activity. The Americans with Disabilities Act also protects individuals who have a record of a substantially limiting impairment and people who are regarded as having a substantially limited impairment. Who is protected continued. An individual with a disability must also be qualified to perform the essential functions of the job with or without reasonable accommodation in order to be protected by the ADA. This means that the applicant or employee must satisfy your job requirements for educational background, employment experience, skills, license, and any other qualification standards that are job related, and be able to perform those tasks that are essential to the job with or without reasonable accommodation. Let's talk about workplace accommodations under the ADA. A reasonable accommodation is any change or adjustment to a job or work environment's marginal functions that permits a qualified applicant or employee with a disability to participate in the job application process, to perform the essential functions of a job, or to enjoy benefits and privileges of employment equal to those enjoyed by employees without disabilities. Also, the first step in the process is the interactive process, is to tell the employer there is a need for an adjustment or change at work for a reason related to a medical condition. An employee can ask for health care provider notes to confirm the disability. And also these notes should be as specific as possible and outline exactly what the employee cannot do at work. Avoid vague terms. Workplace accommodation under the ADA. For example, reasonable accommodation may include acquiring or modifying equipment or devices, job restructuring, part-time or modified work schedules, reassignment to a vacant position, adjusting or modifying examinations, training material or policies, providing readers and interpreters, and making the workplace readily accessible to and usable by people with disabilities. For more information, the Equal Employment Opportunity Commission can help you decide what to do next and conduct an investigation if you decide to file a charge of discrimination, because you must file a charge of discrimination within 180 days of the alleged violation in order to take further legal action, or 300 days if the employer is also covered by a state or local employment discrimination law. It is best to begin the process early. It is illegal for your employer to retaliate against you for contacting the EEOC or filing a charge of discrimination, including participating in a federal investigation. For more information, visit our website at www.eeoc.gov, or you may call 800-669-4000 or visit your local EEOC office. Thank you.
Hello, everyone. I am Dr. Leah Raby, the Executive Director of the Louisiana Commission on Human Rights. My office is the FEPA for the U.S. Equal Employment Opportunity Commission. FEPA is the Fair Employment Practices Agency that works in conjunction with the U.S. Equal Employment Opportunity Commission. And next slide, please. The Louisiana Commission on Human Rights enforces Louisiana state laws that prohibits various forms of discrimination in employment, banking and lending, and public accommodations based upon your race, color, sex, age, disability, national origin, pregnancy, sickle cell trait, or related medical conditions. Next slide. The particular statutes that the Louisiana Commission on Human Rights enforces are the Louisiana Revised Statute 51-2231, the Louisiana Revised Statute 23301, which is also known as the Louisiana Employment Discrimination Law, Title VII of the Civil Rights Act of 1964, Age Discrimination in Employment Act of 1967, Title I of the Americans with Disabilities Act of 1990, and Pregnancy Discrimination Act. Next slide. As mentioned, we have a work sharing agreement with the U.S. Equal Employment Opportunity Commission. This allows the two agencies to simply share our duties and responsibilities seamlessly with each other. We have the same goals and jurisdiction, just one is at the federal level and the state level. It allows EEOC to then have a 300-day jurisdictional limit, and the FEPA has a 180-day. In this agreement, the EEOC and the FEPA effectively provide redress for individuals across Louisiana with state and federal laws. Next slide. So when a complainant files a charge, and you'll hear those terminologies used synonymously, complainant and charging party mean the same thing. Non-jurisdictional cases can be transferred by either agency to one another, and the FEPA should take all cases of mutual jurisdiction as designated by the EEOC as it meets minimal requirements. So a lot of times individuals will call and say, hey, why did my case get transferred to your office? Well, it's no rhyme or reason. It's because we share cases among each other. Both agencies should tell a complainant of their rights to file with either agency, and we do that daily. Any complainant filing a complaint against a state agency, however, should be directed to the EEOC. And why do we do this? So that we can provide the highest degree of impartiality. And we don't want to say that we have been influenced by anyone as it relates to the case that is in our office. And cases that are unsuccessfully mediated within the FEPA or the Commission on Human Rights will then also be directed to the EEOC. And then that case would then go through the investigative process. Next slide, please. So now let's talk about jurisdictional timeframes. With LCHR, because of the work sharing agreement that we have with the EEOC, LCHR jurisdictional timeframe is 180 days from the last alleged act of discrimination or complaint that you've had against your employer. And it extends the EEOC's jurisdictional limit to 300 days from the last alleged act. However, the employer must have at least 20 or more employees to file a complaint with the Commission on Human Rights, but you have to have a minimum of 15 employees to file with the EEOC. As it relates to pregnancy, though, you must have at least 26 employees to file a complaint. But with the EEOC, it's only 15. Now, as it relates to an equal pay complaint, you must have at least 20 or more to file with LCHR and only 1 to file with the EEOC. Next slide, please. The right to bring complaints in court. An employee can also bring a complaint in state court within 1 year of the alleged discriminatory act. This period is actually suspended during the pending review by the EEOC or LCHR up until 6 months. Now, typically, some courts are actually, amenable to any time frame that it's pending within our office, but, give or take. They allow us to apply the administrative process because a lot of times the courts are backed up. Filing with LCHR is not required to pursue a state discrimination claim directly in court, but you may want to contact us before going to court. Now, filing with the LCHR or EEOC within 300 days of the date you believe you were discriminated against is required, however, to preserve your rights of a federal claim. Now let's talk about types of disability discrimination in violation of the ADA, which is the Americans with Disability Act. Let's look at a work situation. The ADA forbids discrimination when it comes to any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoff, training, fringe benefits, or any term of conditions of employment. Now, harassment. ADA forbids harassment of an applicant or an employee because he or she has a disability or had a disability in the past or is even believed to have had a physical or mental impairment that is not transitory or minor. Now, a reasonable accommodation. According to law, an employer is required to provide a reasonable accommodation to an employee or job applicant with a disability unless doing so would cause significant difficulty or expense for the employer. Now note, pay attention to this, reasonable accommodation is any change in the work environment to help a person with a disability apply for a job, perform the duties of a job, or enjoy the benefits and privileges of employment. Now, reasonable accommodations and undue hardship. An employer does not have to provide an accommodation if doing so would cause an undue hardship to the employer. Now, let's look at this. Undue hardship at the accommodation would be too difficult or too expensive to provide in light of the employer's size, financial resources, and the needs of the business. An employer may not refuse to provide an accommodation just because it involves some cost. An employer does not have to provide the exact accommodation to the employee or the job applicant wants. If more than one accommodation works, the employer may choose which one to provide. Next slide. The right to bring complaints in court. I believe we discussed this already. So let's see here. The EEOC has filed more than 200 lawsuits involving claims of discrimination based on disability under the ADA of 1990 and the ADA amendments. Through its litigation program, the EEOC has recovered approximately $52 million in cases involving disability discrimination through jury verdicts, appellate court victories, and court-entered consent decrees, and other litigated related resolutions. Now, let's look at this. Disability-related lawsuits filed have involved workers in the following fields: manufacturing, supply, energy, retail, agriculture, farming, service, hospitality, cleaning, you name it. Just look at this. You have many different fields that is not exempt from which lawsuits can be filed. The commission filed these lawsuits to seek relief for victims of discrimination with a variety of impairments, including but not limited to cancer, emphysema, epilepsy, Fuchs endothelial dystrophy, HIV, spinal stenosis, neuropathy, even depression and anxiety. And the alleged discrimination has included failure to provide reasonable accommodation. So asking prohibited disability-related questions of applicants and employees and refusing to hire qualified applicants based on myths, fears, or stereotypes concerning certain impairments and discharging qualified workers on the basis of a disability. That's a big no-no. Next slide. However, we have a couple of cases that we can review where it does not always work in the favor of the complainant. The complainant versus the FedEx Corporation. In this particular case, there was an operational administrator where the alleged disability was post-traumatic stress disorder. The CP alleged she was involved in an accident which caused her physical pain to her back and neck. And due to the accident, the CP alleged she was diagnosed with PTSD. Meanwhile, the CP alleged she experienced harassment from her manager, and the CP alleged she was involved in another accident, which caused her to take additional time from work. And then further, the CP alleged that when she returned to work, she was sent home without an explanation. However, the CP alleged that she was told there was no investigation in process to evaluate the misconduct. So the respondent contends that the CP was not discharged because of the PTSD, but was terminated for violating company policies. The respondent contends that the CP alleged medical conditions were accommodated by several months of FMLA and non-FMLA leave. Moreover, at a work meeting, upon the CP return to work, the respondent contends the CP refused to cease yelling at her managers and was escorted off the premises. And the respondent also contends that the CP contacted HR to complain about the events that took place in the meeting. Afterwards, the respondent contends the CP was directed to go home with paid suspension until the event from the meeting was investigated. And what happened is the investigation revealed that the CP's termination was a result of her misconduct at the meeting. And the evidence discovered that the CP termination was not due to her disability. Next slide. At the Bella Baton Rouge Casino, a surveillance agent alleged disability was dyslexia, and the CP alleged he was discriminated against based on the disability of dyslexia when he was instructed to get medically tested for the disability. And additionally, the CP alleged that his health insurance with the company was not in effect, and the HR manager required him to get the test done. The CP also alleges that the company would not pay for the test, and his insurance was not available until the day he was terminated. However, the respondent contends that the CP was not easily absorbing the required tasks, and extra time was spent coaching and counseling him. Moreover, the respondent contends that the CP was issued a verbal warning for job performance and given an employment accommodation request form certification of a healthcare provider, then instructed to return the form. The respondent contends the CP admitted that he had not seen a doctor in over 15 years and that the respondent was not obligated to pay for a physical evaluation for the CP. And also the respondent contends the CP did not return the form and was terminated for not performing successfully within the introductory period. So a no-cause decision was actually issued in this particular case because the investigation revealed that both the CP and the respondent confirmed that the CP received the copy of the form and was not completed or returned as the respondent had requested. And then it was a subsequent interview, the CP confirmed that he never sent the particular form back. Next slide. And I'll now turn it over to Attorney Cameron Dawson. Thank you.
Thank you so much, Dr. Raby, for that in-depth explanation, and especially seeing those cases and how it worked out for workers and what to look for under the ADA was really helpful to see. And I also want to thank Marvis for explaining the Americans with Disabilities Act. And as both of our presenters highlighted, you may want to include doctor's notes to certify that you have a disability, but you also want to make sure that you're letting your employer know that you not only have a medical condition that may qualify as a disability, but you also have a need for an accommodation. And that could be the difference between a cause and a no cause violation in some cases. But in any case, definitely reach out to the EEOC and the LCHR if you have questions about your workplace. And you can also reach out to A Better Balance at our free legal helpline. That's 1-833-NEED-ABB. If you have questions about your workplace rights with staying well and maintaining your health while on your job, or just how to go about that conversation with your employer. And I'll also just talk a little bit today about the Family and Medical Leave Act. So next slide. So as a staff attorney at A Better Balance, I often hear questions about workplace rights to medical leave. And we often inform our workers about the Family and Medical Leave Act. And this is a unpaid job protected leave that is about 12 weeks. And it provides certain employees with this right to take it either on a reduced schedule, if you need to have appointments 2 to 3 times a month, or maybe once or twice a week, or you can take this leave all at once and use the 12 weeks all at one time in order to care for yourself or a family member's serious medical condition. Now, it's important to know that this leave can also be used if you are needing unpaid leave while you are pregnant or going to attend prenatal appointments, or if you're a new parent who's caring for your own serious medical condition, such as COVID. FMLA does define a family member as a spouse, parent, or child under 18, unless that person is over 18 and unable to care for themselves mentally or physically. But this does exclude some siblings as well as extended family members and loved ones. Now, you may be able to take this time off in addition to using your accrued vacation leave, or if you have paid time off or a short-term disability insurance program, so that you can make up for that lost income. But it is important to make sure that any leave you take is FMLA, because this is guaranteed job protection. So you can return to your same or a similar position once you are done with the leave. And you also get to continue your benefits such as health insurance. Now, just a little bit more about who is eligible for FMLA. You'll see that there are 3 requirements. You have to have worked at your job for at least 12 months and have at least worked there for about 1,250 hours, which most full-time employees and some part-time employees can make. Now, this 1,250 hours is taken in the 12 months before you need the leave. So if you've been furloughed or off the job, that does affect the amount of hours that you've worked, and you want to double check with HR or your benefits coordinator to make sure you've met that eligibility requirement. And the last requirement is you need to have worked for a job with 50 or more employees, and that 50 or more employees can be within a 75-mile radius. So if your employer has multiple locations, that all adds up within the 50 or more benchmark if it's within a 75-mile radius. Now, if you are covered under the Family and Medical Leave Act, your employer cannot interfere with or retaliate against you for needing to take this time off to care for your health and wellness. So they cannot punish you for needing this time off, or penalize you, or otherwise harass you for needing this leave or trying to see what your rights are under the law. And in addition to FMLA, some employers actually provide their own leave of absence policies or unpaid time off if a supervisor provides the approval for that leave. So it's important to see, what your employer's policies say about the FMLA and other types of leave. But if you believe that your employer has interfered with your rights or has retaliated against you, please feel free to contact the Department of Labor. They also have some fact sheets and information about the FMLA at www.dol.gov, or you can also contact our free and confidential legal helpline at 1-833-NEED-ABB. Next slide, please. And like I said, there are some additional protections under the FMLA where your employer cannot penalize you or give you points for leave taken under the FMLA. Now, under some employers' policies or workplaces, they may give a worker a disciplinary point, such as a half point or a full point for being absent due to a disability or for taking care of themselves or missing work or leaving early. But under federal and state law, this is not only unfair, but in many instances, it could be illegal. So it's important to make sure that if your job does have these types of policies, that they are taking off these points if they are approved under the FMLA or if they are approved under the Americans with Disabilities Act as an accommodation. And you can see more information about your rights if you think you are being unlawfully punished or even terminated under your employer's abusive attendance policies by visiting A Better Balance, and we'll help walk you through your rights there. And like Marvis and Dr. Raby said earlier, there is also unpaid leave as a workplace accommodation. So that list that we gave earlier is not just the only types of accommodations you can ask. It all depends on your medical needs. So even if you are not eligible for the FMLA because you only work part-time or you may have just been on the job for 90 days, not a full year, you may be able to request time off or another accommodation through the Americans with Disabilities Act. And so if you work for an employer with 15 or more employees and you have an impairment that substantially limits a major life activity like your breathing, walking, your ability to stand for long periods of time, you may have the right to receive and request an accommodation, just as long as that accommodation does not impose that undue hardship, which again is meaning that it's very difficult or it's very expensive for your employer to provide. And although your employer does not have to provide you with the first accommodation that you suggest, they do have to work with you in an interactive process or a conversation to see if there's an alternative accommodation that can be made. And if there is an accommodation on the job that can keep you working, your employer can't force you to take unpaid leave unnecessarily. So it's important to see, how other employees have been treated in the past, what those handbook policies say, or if there's a separate ADA process at your job to complete the accommodations request. And just to sum up again, not just what we've seen with the FMLA, but we've also seen this when workers are given points for accommodations under the ADA as well as the Pregnancy Discrimination Act, that if you start to see that you are giving your employer is giving those points for some absences, or if you need to dock your bank of time for missing work, that can potentially lead to disciplinary action and sometimes termination. We've seen in some cases that if you have received up to 4 or 6 points, then that can lead to termination. But some of those points may need to be waived because they're approved under the FMLA or the ADA accommodations policies. So these policies, we really do feel are abusive, and they tend to punish employees for taking care of their health and their family's health. And we want to recognize that and just let you know that You don't have to be an expert on these laws, but our goal today is to really inform you of your rights. And if you have questions, you have those resources so that you can continue to take care of your health and the well-being of your family. So again, definitely feel free to reach out to the EEOC or the Louisiana Commission on Human Rights if you have questions about what we've talked about today. And then you'll see on the next slide, there are some additional resources, just if you have questions about Louisiana laws on our A Better Balance Know Your Rights page. And that does give a breakdown of how to request an accommodation, how to request time off to recover from a serious medical condition. And you can also give us a call if you have more questions. And next slide. And so we want to thank you today for viewing this presentation, and feel free to reach out to any of the resources here if you have additional questions. And we hope you stay safe and be well.